Toronto appellate lawyer Jason Squire has the Lerners Appellate Group Top 5 appeals for the month of December 2012. Well, Jason, what's number 1 on the list?
Well, first we have a case called Canada Trust in Browne. That was a case involving the interpretation of the trust that was set up for the grandchildren and great-grandchildren of the founder of Primo Foods. That trust was set up as what's called a unitrust, or a percentage trust, which allowed the income beneficiaries to receive a set amount every month. What's unique about those trusts is that the trustee does not have to apply any consideration to the potential conflict of interest between the income beneficiaries and the capital beneficiaries. Unfortunately, because of declining markets, the capital beneficiaries were concerned that the amounts paid to the income beneficiaries would erode the capital of the trust, and the trustee sought directions from the court. It's an interesting case because it delves into some fundamental trust principles. The children's lawyer represented the capital beneficiaries, and Lerners was acting for the children's lawyer in that case.
What's number 2 on the list?
Next, we have a case called Dembeck Wright. That involved a husband who was terminated from his job, received a termination payment which included a severance payment, and then 3 days later his marriage with his wife disintegrated. The question in that case was whether the severance payment that formed part of the payment that he received was effectively an asset of the marriage, or an asset of the husbands at the time that they entered into the marriage, and was necessary to be accounted for in the net family property calculation in that case. Interestingly, the Court of Appeal found that no, that was not an asset that had to be taken account of at the time he entered into the marriage, because it had not crystallized when the marriage started.
Moving on to number 3.
Third, we have a case called Trang and Nuen. In that case, the Canada Revenue Agency had applied liens to properties owned by the taxpayer who was well in arrears. His wife and also his sister asserted equitable interest in the land. Those equitable interests were never registered, and the CRA was asking whether those unregistered equitable interests could take priority over the registered liens that the CRA had put on the property. And in short answer, the answer was yes, it could, and presumably they'll be off to trial to sort that out.
And tell us about number 4.
Fourth, we have a case called St. Mary's Cement and the municipality of Clarington. St. Mary's Cement wanted to adopt alternative fuel in its manufacture of cement, and the municipality of Clarington opposed on the basis that they believed that that would effectively turn St. Mary's factory into a waste disposal site. The Court of Appeal said that was not the proper interpretation of the municipal bylaw in the circumstances, and effectively said that the use of alternative fuel did not change the use of the cement factory to something altogether different.
And rounding out the list.
And last, we have a case called Briscoe Estate and Canadian Premier Life Insurance Company. That case is an interesting primer on the hearsay rule, and particularly how you use hearsay evidence in a case involving, in this case, a deceased person who had ordered life insurance. Mr. Briscoe had ordered life insurance from the defendant, but the defendant took the position that he had canceled it over the telephone some months later. However, over the course of his remaining life, he always told his family that he had life insurance. And so after he died and Canadian Premier took the position that he did not have the life insurance, the family wanted to rely on the evidence of Mr. Briscoe, or the evidence of his statements throughout his life that had said, where he had said that he believed that he had life insurance. Ultimately, the jury in that case and the Court of Appeal agreed that it was proper to use that evidence to infer that in fact it had been Canadian Premier Life Insurance Company's mistake, and not Mr. Briscoe having terminated the life insurance.
Well, thank you very much.
Thank you.